Hi, my name is Lily Chambers, and today I'm going to be discussing whether I think it's time for English law to embrace a duty of good faith in the performance of all contracts. I'll do this by splitting the presentation into four sections, which will be the introduction, the reasons why duty of good faith should be adopted, number three, which will be reasons against the adoption of duty of good faith, and then how I will conclude. So first is the introduction, which will cover what good faith is. Good faith is essentially the notion that parties should consider the other side and act fairly throughout the process of forming a contract. As the notion of good faith in the UK as it stands is that it isn't recognised, which is unlike a lot of other nations, especially those that have a civil law system. Even though it isn't acknowledged in a traditional sense, it has some recognition and adoption within the UK law system. This can be seen in Berkeley Community Villages v Pullen, where it demonstrates the court taking a narrow approach when interpreting express terms in imposing a duty to act with good faith. The Justice Morgan in this case held that the good faith obligation required the parties to observe reasonable and commercial standards of fair dealing in accordance with their actions which related to the agreement. And he did this by putting it down to three elements, where the parties must observe reasonable commercial standards of fair dealing, to be faithful to the common purpose, and to be consistent with the justified expectations of the other contracting party. And this is what is still currently used to apply to duty of good faith agreements. Duty of good faith isn't a completely new notion to the English law system. It's already been looked at and examined by the House of Lords in the case of Director General Fair Trading v First National Bank. And they looked at this within the context of the Unfair Terms in Consumer Contracts Regulations, or the UICCR. In terms of what the House of Lords decided is that the concept isn't completely unfamiliar to British lawyers, and it should be treated as a broad concept of fair and open dealing in order to ensure that when contracting takes place, the procedural and substantive fairness is upheld. However, the House of Lords didn't say that it should be introduced in a more solidified way, in the way that we're discussing today, whether it should be adopted completely into the British law system. There have been cases such as Yam Seng that have set the precedent of how the English courts should behave when it comes to breaches of contracts with the principle of good faith. With Yam Seng, Justice Legat's conundrum was whether in English law there was no obligation of good faith, and there wasn't, and there isn't to this day. There isn't this obligation. So he suggested that they should adopt an objective contextual based presumed intention to perform good faith in all commercial contracts. So the idea is that where it is in contracts, whether this duty of good faith should be upheld should be based on the context of the case itself, rather than it being a blanket thing that is applied to all contracts, as not all contracts will have it included. And this case provided the question of whether English law needs to adopt an umbrella term of good faith, as because it hasn't been adopted in a traditional sense within the UK, there isn't really an umbrella term on what it means. It's very, as Legat said, it's very objective, and it's based on the context of which it's set in. The judgment provided by Legat in the Yam Seng case, it was quite a controversial case, and it was a case that provided a lot of discourse on people siding with Legat and agreeing with his notion and his take on the notion of good faith, but also people on the other side that were highly criticized it. And this slide will discuss that discourse. So an academic who agreed with the Amseng was Collins, who said that the broad doctrines that such as good faith would provide a gateway to allowing social science perspectives to become relevant legal doctrine, and that it will help rebuild private law in a more contextual way, instead of it being broad sweeping principles and notions. It will allow court cases to become more individualized and for rulings to be made on the context rather than just what's been done before. However, on the other side, academics argued that the Amseng judgment, when applied, this application of good faith will interfere with the freedoms of contracting, because it affects the parties and the negotiated terms, because it forces the parties and it forces the contract to behave in a particular way in order to provide these open and fair dealings. Additionally, the Legat judgment didn't disclose the content of what good faith would be, or the scope of what good faith would be or should be, which affects how it can play a part, what part it can play in law. However, this in itself isn't necessarily a weakness, as some skeptics say it is, but rather it could instead be a flexibility, because by not having a strict judgment, by not having a strict definition of what good faith is and a strict scope that within that justices and judges have to keep to, it means that it can be applied within the context of the case rather than based on precedent. Now we'll move on to the second chapter of this presentation, which is in support of the duty of good faith and why it should finally be applied in English law. The first reason is the international recognition of good faith. In Legat's judgment, he made a comment of how English law is swimming against the tide, and this is due to other countries, such as France and many others throughout the world, having already implemented the notion, which has left the UK on the outside, with them being a unique law system for them not to have applied the notion and adopted it. And the reason why this makes us swimming against the tide and puts English law in a very unique position is that the English law and English courts are chosen to deal with a lot of international commercial disputes. And because of this, many of these contracts will have been formed and will include notions of good faith. And because of this, in a more official way, the notion of good faith should be added to the system, as the courts don't currently have any provisions of it, despite the fact they will have to uphold the notion of good faith. For them not to have the notion in this concrete way, as the previous slides mentioned, it could potentially, in this very moment with it not being adopted, be contributing to a lack of standardization in the application of the notion. Another thing that shows the benefits of adopting the notion of good faith is by looking at Lord Stein's perspective. He said that English law serves as the international marketplace. It cannot remain impervious to the ideas of good faith or of dealing, which links back to my previous slide. However, his perspective was that there isn't a need for hostility towards the notion, and that despite critics saying it's hard to apply and understand, that it is in fact entirely practical and workable into our current system. This is because, as Lord Stein also pointed out, the principles that of international commercial contracts, which the UK has to follow, already states that trading of good faith must be displayed and cannot be stopped. And that is applied to both UK, whenever the UK parties and international parties enter within contracts to one another. So if some UK companies are already having to follow this principle and this notion, then why shouldn't it be applied to all UK parties entering contracts, rather than only being adhered to at some points? When looking at examples of good faith being implemented abroad, it's easy to draw a comparison to French courts, which don't have this one good faith application, but good faith is seen as an array of obligations to encourage the duty of loyalty as well as cooperation, rather than it being a single rule that's very strict. By doing this, it allows parties to utilize their contractual right in a way that both benefits them, and provides that should they have a suitable reason, they can't abuse their contractual position, which means that, unlike criticizers, this, because of France adopting it in this way, it doesn't mean that the parties have has more control, have less control. Now we are moving on to the third section of the duty of good faith, which is why it shouldn't be adopted. Firstly, the courts that are having to would have to implement this notion, view it as unclear and difficult to apply, as seen in the Compass Group case. In the judgment, Beatston wanted to limit the good faith of Yamseng, and did, as the duty was heavily conditioned by its context, which meant that where he viewed that if it's conditioned by its context, it may not be fairly implemented like the intention would be. And if these concerns of the courts cannot be addressed, then implementing this notion would be pointless, as judges wouldn't apply good faith any more than they do now, because they wouldn't know how to accurately apply good faith. As we discuss why good faith shouldn't be adopted into the English law system, we should look at the case of Hampsad, where the Justice Norris restricted the application of Yamseng, saying, "I do not accept that there is to be routinely implied some positive obligation upon a contracted party to subordinate its own commercial interests to those of another contracting party." Here he's essentially saying that enforcing parties to adhere to this notion of good faith, they are also sacrificing their own interests. By doing so, it would be unfair on these parties, and it could have catastrophic consequences. Now moving on to the conclusion, which is why good faith should be introduced is why I think that overall good faith should be introduced into English law. First, I want to look at it in context of the BIICL's Concept Note 3, which stated that the notion of good faith should be embraced with all contracts in the UK, essentially saying that the notion is needed to be adopted to ensure that all contracts can have standardised application, rather than being at the discretion of the judge, which will ensure fairness and correct interpretation. So to conclude, the concept of good faith has long been debated between academics and has slowly begun to emerge itself. However, I think it should be fully adopted, as it will ensure that parties behave in a fair and open way throughout the conception and performance of a contract. And additionally, if it was solidified within our system, it will provide a concrete definition that can be enforced and won't be open to interpretation as critics currently fear. Thank you for listening to my presentation.